Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of civil procedure, that too in relation to matters involving setting up of counterclaim. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
In the important judgment titled Satyendered and Others versus SAROJ and Others, pronounced on 17th August 2022, the Supreme Court has held that a counterclaim can be set up only against the claim of the plaintiffs. The facts of the case would be that plaintiffs filed suit claiming to be owners of the sued property. In addition to the written statement of the defendants, a counterclaim was also set up by the defendant number 2, stating that in addition to the Khasra and Kilar numbers given in the plaint, he was also in possession of 2 other Kilar numbers in question. The suit was dismissed on the findings that the plaintiffs could neither prove their right on the property nor could they prove the fact that the defendant number 2 created a subtenancy in favor of his son, that is, defendant number 1. However, the counterclaim was decreed. The first appeal filed by the plaintiffs was also dismissed. The matter was taken in second appeal by the plaintiffs. Though the High Court upheld the findings of the 2 courts on the subletting and tenancy and upheld the findings of the lower courts in favor of the defendants, as there was no subletting of the land. Yet, in the same breath, the High Court allowed the claim of plaintiffs on the 2 plots for the reasons that for these 2 plots, though the plaintiffs raised their claim and the defendants did not raise any counterclaim on these plot numbers, which went uncontested. In addition, it was also held by the High Court that the counterclaims set up by the defendant could not be decreed, since the plaintiffs themselves did not set up any claim whatsoever for these 2 plots, and therefore, under provisions of Order 8 Rule 6A of the CPC, an independent counterclaim having nothing to do with plaintiffs can never be allowed. Being agreed, the present appeal has been filed. The Supreme Court has held that Section 100 of the CPC mandates that a second appeal would lie before the High Court only on a substantial question of law, and a second appeal has to be heard on the substantial question of law, so formulated by the High Court. However, the present dispute is from Haryana, where the governing provision would be Section 41 of the Punjab Courts Act 1980 and not Section 100 of CPC. Therefore, in the state of Haryana, a court in second appeal is not required to formulate a substantial question of law. Consequently, it was not necessary for the High Court to formulate a substantial question of law. Though the requirement of formulation of a substantial question of law was not necessary, yet Section 41 of the Punjab Courts Act requires that only such decisions are to be considered in second appeal which are contrary to law or to some custom or usage having the force of law, or the court below failed to determine some material issue of law or custom or usage having the force of law. Therefore, what is important is still a question of law. The facts of the present case would show that the plaintiffs failed to prove their case as owner of the land in dispute. Hence, their case of declaration and possession was dismissed. The second appellate court, however, quite erroneously and without any justification, gave an entirely new finding reading two KILA numbers on which the plaintiffs claim relief of declaration and possession on the same grounds as raised by them for the other KILA numbers. The pleadings also show that the defendants made a general denial of the plaintiff's claim for all the plots. Yet the High Court held that since the defendants did not make any claim for plot numbers in question and therefore by logic a decree of declaration of possession ought to have been given to the plaintiffs for these plots. This reasoning of the second appellate court is erroneous for the simple reason that the burden of proof was on the plaintiffs to prove their case, which they failed. They were not able to prove to the satisfaction of the trial court as well as the first appellate court about their claim of any kind over this property. Mainly because the defendant did not raise a counter claim on this property, it would not ipso facto mean that a decree ought to have been granted in favor of the plaintiffs. Plaintiffs have to prove their case on the strength of their evidence. For this reason, the reasoning given by the second appellate court for decreeing the claim of plaintiffs for plot numbers in question is incorrect and to that extent is liable to be set aside. The other findings of second appellate court regarding the counterclaim of the defendants on KILA numbers is, however, correct and is based on right interpretation of Order 8 Rule 6A of CPC. From the pleadings of the plaintiffs, it is clear that they never raised any claim on KILA numbers in question. The defendants in their written statement while denying the rights of the plaintiffs on the land of which particulars were given by the plaintiffs quite ingeniously inserted the two KILA numbers in question, setting a counter claim on these plots. The trial court and the first appellate court, while dismissing the plaintiff's suit, allowed this claim for without assigning any reason. In fact, this counter claim which was raised by the defendant is barred under Order 8 Rule 6A of the CPC. A counter claim can be set up only against the claim of the plaintiffs. Since there was no claim of the plaintiffs regarding disputed KILA numbers, the defendants were barred to raise any counter claim on these KILA numbers in view of Order 8 Rule 6A of the CPC. As it has nothing to do with the plaintiffs, it is true that a counter claim can be made by the defendant even on a separate or independent cause of action. The legislature permits the institution of a counterclaim in order to avoid multiplicity of litigations. But then it has certain limitations such as that the counterclaim cannot exceed the pecuniary limits of the jurisdiction of the court and that such counterclaim must be instituted before the defendant delivered his defense or before the time limit for delivering his defense expired. More importantly, such a counterclaim must be against the plaintiff. Evidently, in the present case, the counterclaim was not against the plaintiffs. Moreover, as the plaintiffs did not claim any right over the property and the KILA numbers in question are not even a part of the suit property described in the plaint by the plaintiffs. Despite the same, such a claim was allowed against the plaintiffs. In fact, this court does not find any replies submitted by the plaintiffs against the counterclaim. To be fair, such a counterclaim should have been excluded in terms of Order 8 Rule 6C of the CPC. Suffice it to state that the counterclaim set up by the defendants was rightly rejected by the High Court. The judgment and order passed by the High Court to the extent that it decreed the claim of the plaintiffs on KILA numbers in question is hereby set aside.